Stick around. Move more 6 o'clock.
Need a waiver.
Oh, I call that one.
I want to see if you talk to the council, see if, yes. He's here for that, he's here for that.
May I approach him?
Yes. And we call this how we got this, something she's asked.
We need to be inside. We do. No, yeah. He's here.
All right, this is the matter of State of Ohio versus Marcus Herndon. Case number B2600471. Mr. Herndon is present with his attorney, Mr. Aaron Levinson, Mr. Nick Crosswell with the State of Ohio. Am I pronouncing your name correctly? Herndon. Herndon?
Yes, but that's not what.
All right, thank you. This matter is set for a jury trial today, and I've been handed plea documents. Mr. Levinson, is the same client wishes to proceed?
It is, Your Honor.
All right, Mr. Herndon, is this accurate?
Yes, Your Honor.
Are you the Marcus Herndon named in this indictment?
Yes, Your Honor.
Mr. Herndon, how old are you?
24 years old.
And how far did you go to school?
I got a few credits within my first year of college, and I dropped out.
All right, would you mind turning that microphone on to green? Thank you. So you graduated high school, you have a few credits of college?
Yes.
All right. So you're able to write the English language well?
Yes.
Are you a U.S. citizen? Are you a U.S. citizen?
Yes, sir.
Have you ever served in the military?
Yes.
Mr. Herndon, I have in my hand a single-page document entitled Waiver of Trial by Jury. The bottom there are signatures. I recognize Mr. Levinson's signature here, but right up here where it says signature, who is the defendant. Is that your signature?
Yes, Your Honor.
This is an acknowledgement by you that you understand that you have a constitutional right to the trial, which was set for today. But when you sign this form indicating to the court, I understand my constitutional right to the trial, but I don't want to have a trial. I'm waiving my right to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, Your Honor.
Did you sign this form after consulting with your attorney about your constitutional right to the trial?
Yes, Your Honor.
Do you have any questions about this form?
No, Your Honor.
Do you have any questions about your constitutional right to the trial?
No, Your Honor.
I also have in my hand a 2-page document, and it's entitled Entry of Joint Plea of Not Guilty, Entry of Plea of Guilty, Reduction to Misdemeanor. On the bottom of page 2, there are signatures. I recognize the prosecutor's signature here, Mr. Levinson's signature here, right there for his signature of the pen. Is that what you signed?
Yes, Your Honor.
All right, thank you very much. Mr. Prosecutor, would you please put on the record the party's expectation regarding this plea?
Your Honor, we changed the plea from not guilty to guilty to amended count one reduction to amendment to assault, misdemeanor first degree.
All right, thank you. Mr. Levinson, is that accurate?
It is, Your Honor.
Mr. Herman, is this your understanding as well?
Yes, Your Honor.
Are you under the influence of any medications, alcohol, or drugs today?
No, Your Honor.
Do you now, or have you ever had to manage any type of mental health difficulties?
No, Your Honor.
Are you presently under any type of probation or community control supervision in this state or any other state?
No, Your Honor.
Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today?
No, Your Honor.
Has anyone promised you anything at all if you went into this guilty plea today?
No, Your Honor.
Are you making this plea of your own free will?
Yes, Your Honor.
Now, the state has indicated that this is a single count indictment. You're charged with felonious assault, a felony of the second degree, which in our system is next to the highest. So in our system, felonies are the highest, the first, then the second, then the third, fourth, fifth, then misdemeanors. Misdemeanor 1, 2, 3, lowest is 4. Do you understand that in my misdemeanor?
Yes, Your Honor.
You're charged with a felony of the second degree. It's my understanding that based on your attorney's negotiations with the state on your behalf, that the state is asking the court to amend and reduce this charge from a felony of the second degree, felonious assault, down to a assault misdemeanor of the first degree. Is that your understanding of what's happening today?
Yes, Your Honor.
Did you have an opportunity to review this two-page plea form with your lawyer before this hearing today?
Yes, Your Honor.
Do you understand what it says?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
Did Mr. Levinson answer all of your questions about it?
Yes, Your Honor.
Mr. Herndon, do you believe you've had enough time to sufficiently consult with your attorney about your entire case before this hearing today?
Yes, Your Honor.
And has your attorney answered all of your questions to your satisfaction?
Yes, Your Honor.
Have you had an opportunity to either review and or discuss the evidence the state has against you with Mr. Levinson before this hearing today?
Yes, Your Honor.
Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge to the defense?
We have, that's my knowledge, Your
All right, Mr. Levinson, you acknowledge receipt of same.
I do, Your Honor.
Mr. Herndon, are you satisfied with your attorney, Mr. Levinson?
Yes, Your Honor.
Now, this being a reduced and amended to an assault, a felony of the misdemeanor of the first degree, do you understand that charge against you?
Yes, Your Honor.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the charge and the allegations of assault, a misdemeanor of the first degree?
Yes, Your Honor.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, Your Honor.
Now, this being reduced and amended to assault, misdemeanor of the first degree, do you understand that you're facing up to 180 days in jail and up to a maximum fine of $1,000?
Yes, Your Honor.
Do you also understand that since this is being reduced to a misdemeanor of the first degree, that community control or probation is a possibility?
Yes, Your Honor.
Do you understand that I can place you on probation for up to 5 years instead of sending you to jail?
Yes, Your Honor.
Do you understand that if you are placed on a probation sentence or a community control sentence, that you have to abide by all probationary conditions as established by this court?
Yes, Your Honor.
And do you understand that if I place you on community control and you violate conditions of community control, then you're going to be brought back before me for a more restrictive sanction, which could include a whole host of penalties, but the most severe penalty could be the imposition of jail time up to the 180 days I just previously discussed with you. Do you understand that?
Yes, Your Honor.
Also, If I impose court costs and you fail to pay those court costs, I can order you to do community service instead of paying court costs. Do you understand that?
Yes, Your Honor.
Now, Mr. Herman, if I were to place you on community control, I would fully expect that you would be successful. But can I tell you a few ways that people are not successful and what happens when they're not?
Yes, Your Honor.
All right, the first biggest way that someone is not successful is that they commit a new offense. They're convicted of a new offense. That is an automatic and immediate direct violation of probation or community control. Do you understand?
Yes, Your Honor. Do traffic violations include in that?
Depends. Depends on the traffic violation involved. Drinking and driving. But speeding typically does not. But that's a good question, thank you. The second biggest way is that some people just don't completely comply with all the conditions of probation. So if there are 8 conditions and you only complete 6 or 7 or even 7.5, well, that's not 8, and that's a direct and immediate violation of probation. You understand?
Yes, Your Honor.
And then the third biggest way that some people violate that is not as commonly known, and that is some people leave the state without permission of probation and or the court. Do you understand that?
Yes, Your Honor.
That's an immediate and direct violation of probation leaving the state without permission. You understand?
Yes, Your Honor.
All right, and the reason that becomes very important is because we, as a parents, we join several states. Kentucky, across the river, right? North Kentucky is not Ohio, so it's violation. Indiana, another part of our state, and Michigan, another part of our state. So that's why it becomes very important. Do you understand that?
Yes, Your Honor.
Any questions so far?
So Judge, his question is related twofold. One, he's with us and when we give him this letter of Kentucky, and 2, he's in the military. So I guess we can address that at sentencing.
All right. When you plead guilty, you give up some very important constitutional rights, and I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, Your Honor.
Do you understand you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, Your Honor.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify on your behalf?
Yes, Your Honor.
Do you understand that a trial is the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
And finally, do you understand that at a trial, you cannot be forced to testify against yourself?
Yes, Your Honor.
Do you understand each of these rights that I explained them?
Yes, Your Honor.
Do you have any questions about their constitutional rights?
No.
Do you have any questions about anything we discussed here today?
No.
Do you understand that if you plead guilty, you are waiving all of these important constitutional rights in this case?
Yes, Your
Mr. Herman, knowing everything the court has discussed with you, do you still wish to enter a guilty plea to the reduced and amended charge of assault and misdemeanor of the first degree?
Yes, Your Honor.
Counsel, is there anything further before I accept the plea?
No, Your Honor.
And your statement of facts?
November 23rd, 2025, Pembroke County, Ohio, offended knowing cause physical harm to John Tindley. He struck him in the head on
All right, thank you. Anything on the facts, counsel?
No, Your Honor.
Mr. Herndon, did you hear what the prosecutor said you did?
Yes, Your Honor.
Is it true?
Yes, Your Honor.
What is your plea to assault, misdemeanor of first degree outline?
Yes, Your Honor.
Let the record reflect that Mr. Marcus Herndon was present in court with his attorney, Mr. Aaron Levinson, and that Mr. Herndon was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Herndon understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the plea and finds Mr. Marcus Herndon guilty as to count 1, assault, reduced and amended to assault, a misdemeanor of the first degree in violation of revised code 2903.13. Counsel, is there any reason why the sentence should not be issued today?
No, Your Honor.
All right. Are you waiving the PSI?
We are, Your Honor.
Has the state, had an opportunity to file a process law? All right, I see that Mr. Herman has no record in the state of Ohio.
That is correct, Your Honor.
All right. Does he have any consent?
He had a disorderly conduct ticket and paid out, but there's no record other than that.
All right, thank you very much. Who would like to sit on behalf of Mr. Herman?
Thank you, Your Honor. Mr. Herman is standing for the board 24 years old. He is not someone who is a habitual troublemaker. He is in the National Guard, has been in the National Guard for 5 years. The National Guard is aware of this case and has been tracking it. If he was convicted of a felony, in addition to those charges, he would face a court martial. Even with this misdemeanor, he's going to go before court inquiries related to his conduct. They obviously hold him to a very high standard. He realizes that he let himself down, let Mr. Dippin down, and that this behavior is not at all acceptable, and that he came very close to ruining his promising future. He, in addition to working in the National Guard, works as a painter for Deck Painting, both commercial and residential painting. He lives in Fort Thomas. He is otherwise an unremarkable person that should make a terrible error in judgment on this day. This event is done outside the Orlando Stadium. The victim was the traffic jam. I was walking across the street, the victim was struck in the car, and I was upset through a hand. The victim got out of the car and it was not an indication of his victim's behavior generally or his character. It was just a little lapse of judgment, and he's incredibly sorry. I would hope that the court would pay attention. We have tendered to the victim restitution check in the amount of $3,500, which covers medical costs related to this incident. Mr. Herman is incredibly merciful and requesting mercy of the court. I believe Mr. Herman wants to apologize.
All right, well, I will let him, give him an opportunity to sworn. All right, state.
Yes, right after the Bengals game, on 3rd Street, prosecuting witnesses into his car trying to get home. Fear of being struck in the back windshield. Just simply assumed that alcohol was involved in the decision at the time after the game. Mr. Julia had his car to see what was going on, where the third game was in his car, complication ensued. Mr. returning to his car, he got punched in the back of the head. His head actually hit his car on the dent in his car. He suffered a brain bleed, was treated at the hospital. Unfortunately, they were able to get it under control that evening. However, due to striking his car with his head, he did suffer some neck injuries, had to suffer a physical therapy. Nothing broken, fractured, but just kind of strained, hypertension, kind of RFA. So he did have to go to physical therapy. He's still kind of dealing with a little bit of stiffness in his head. Fortunately, nothing too serious outside of the initial symptom, concussion-like symptoms. He, speaking with him, he did not wish to see this derail his life and his career. He didn't say go to prison. Did think this was an appropriate solution. He was very forgiving of everything in my opinion.
Is this your name? All right, what's his first name?
John.
Does he want to speak?
He did not.
How do you spell his last name?
Dittily. So,
Dittily.
and
Dittly.
Yes.
T's, not D's, okay. Thank you. All right, Mr. Herman, what would you like to say before I pass sentence?
I would like to apologize to you. It was very disrespectful of me and just so bad. It was just bad. It was very bad. I should have. I'm very sorry. I shouldn't have put you to do that. It's not that. So, for the last 5 years of my life, I'm sexually assaulted. Yes, I can. Mistakes happen. I'm just, I really apologize. I shouldn't have done. I'm proud of you guys that you guys are, that's a lot of, you take my goodness, you consideration. I'm proud of you guys that, I would never have another problems, having others, livers and marches, and almost catching film, amazing, along with all these things. You guys can deserve that, you guys are trying to go for you.
Thank you.
Also, last of all, I got to see the court flag as a member of the National Guard. I'm sergeant, I have leadership that's been spoken. I think back, I know, like, I just did love the coach and on the other side, I should have with it. So, shame, I hope I can continue serving. Just prove that I'm here, and that should have been the first thing before Sunday.
Any restitution?
It's been, taken care of.
So zero restitution for us. All right, couple things that, you said that resonated with me. Number one, you're absolutely right. We don't expect our National Guard members or any of our armed forces members to behave that way. Because we understand that you represent the United States and that, your training and your experience require you to take a high. But in this instance, you cause harm to an innocent person, someone who didn't deserve it, and you said that already. And instead of you taking the high road, they took the high road. I am always humbled by a victim who takes the high road when they've been harmed. I'm always humbled by that. I'm always humbled by forgiveness, the act of forgiveness, the act of kindness, which is what we're all called upon to do. This could have been very, very different. This could have gone very differently. Not just the incident, but today. Because this whole case could and would have derailed your whole career. But I have to consider the fact that the harm that you caused Mr. Diddley derailed his life. And I hope that if you ever find yourself in this situation again, that you will act differently. The court has considered the provided purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I recently calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact not only on Mr. John Diddley, but also on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Mr. Herndon, I hereby sentence you to a term of 18 months community control, intensive supervision. You will pay court costs. There will be no fine. Zero restitution is requested. You will stay away from Mr. John Diddley's wife. Mr. Diddley is the name video. And should you violate the conditions of probation or community control in the next 18 months, I will not hesitate to sentence you, in the worst case scenario, to 180 days in the Justice Center. Do you understand?
Yes.
Now, I will tell you that a violation, any violation of community control could result in a longer period of community control. I put you on 18 months, but it could result in a longer period of community control. It could be, there could be additional sanctions, according to the level of offense. And, the worst case scenario is 180 days in jail. Do you understand that?
Yes, Your Honor.
All right. Anything else, counsel?
No, thank you, Your Honor.
Steve?
There you are.
All right, Mr. Herndon, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Yes, Your Honor.
All right, you'll have to go over your probation, right now. Ms. Howard is sending over the, paperwork ahead of you, so you won't have to wait. And, they'll just talk to you for a minute if you sit and sign up, and you'll be free to go. Okay?
Judge, I just thought of something, since he is in the military, you will have to use firearms, or be around firearms, but it's not duty, I don't know what the conditions of this in the probation are. Usually in relation to firearms, but I do want to confirm that while he is on active military duty, he is not prohibited from doing so.
That presents a security situation. Let him report to probation. Tell his probation officer will contact me, and then we will, make any adjustments. He certainly is in the military, so, he needs to be able to do that, we'll make any adjustments as necessary.
Thank you, Your Honor.
All right, thank you.
Have a nice day.
All right, counsel, for the trial, we have a jury questionnaire, let me give those to you now, so we can be looking at them. Yes. All right, ready for Eddie Willis?
Mr. Wells, Your Honor.
Whatever you guys think.
Sure. I'm gonna go check most of my victims are in another room, and I'll go back. Okay.
This is the matter of state of Ohio versus Eddie Willis, case number P250653. Mr. Willis is present at courtroom with his attorney, Mr. Al Aaronstein, and Mr. Nick Croswell of the state of Ohio. Off the record. I see that Mr. Willis has a client with him.
He does, Judge.
Does he need to be close by?
No, it's fine.
Okay.
to go to school. Parents to go to school.
All right, so this matter is set for a plea, I can hand the plea documents. Mr. Aaronstein, is this how your client wishes to proceed? All right, Mr. Willis, is that accurate? All right. Are you the Eddie Willis named in this indictment?
Yes,
Mr. Willis, how old are you?
36.
36?
Yes.
How far are you going to school?
High school.
Did you graduate? So you're able to read and write English language well?
Yes.
Are you a U.S. citizen?
Yes.
Have you ever served in the military? Mr. Willis, I have in my hand a single-page document. It's entitled Waiver Trial by Jury. At the bottom, there are signatures. I recognize Mr. Aaronstein's signature here. Right above, looks like it's just an E. That's how you sign your name.
Yes.
All right. This is an acknowledgement by you that you understand you have a constitutional right to the trial. But when you sign this form, you're indicating to the court, I understand my right to the trial. I don't want to trial. I'm waiving or giving up my right to the trial. Is that your understanding of what you were doing when you signed this form?
Yes.
You signed this form after consulting with Mr. Aaronstein about your constitutional right?
Yes.
Do you have any questions about this form?
No
All right, do you have any questions about your constitutional right to the trial?
questions.
I also have in my hand a 3-page document. And it's entitled Entering the Plea of Not Guilty, Entering the Plea of Guilty. On the 3rd page, there are signatures. I recognize. Is that your signature, Mr. Castle? I was giving a hard time about the signature. Okay, this is, I recognize Mr. Russell's signature there. Mr. Aaronstein's signature here, along with his Supreme Court number, and is this your signature right there, sir?
Yes.
All right. Where it says signature of defendant. Is that right?
Yes.
All right. Mr. Prosecutor, please go on record the party's expectations regarding this plea.
Your Honor, the defendant should plead from not guilty to guilty on count 2. It would dismiss count 1 pursuant to that plea.
Mr. Aaronstein, is that right?
That's what I understand, Judge. Do I make forfeiture of the weapon?
You did?
Okay.
Thank you. And is that your understanding?
That's your understanding? Yes.
I'm asking you, Mr. Ernst.
Oh, yes, sir.
Okay, Mr. Willis, is that your understanding as well?
Yes, it is.
All right, thank you. Mr. Willis, are you under the influence of any medications, alcohol, or drugs today?
No.
Do you now, have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this state or any other state? Has anyone forced, threatened, or coerced you in any manner into entering into the plea of guilty today? Has anyone promised you anything at all if you enter into this guilty plea today? Are you making this plea of your own free will?
Yes.
Now, the state is indicating this is a 2-count indictment. Count 1, carrying concealed weapon, felony 4th degree. Count 2, having weapons while under disability, and felony 3rd degree. I am told that it's expected you'll enter a guilty plea to count 2, having weapons while under disability, felony 3rd degree. In exchange, the state's going to ask the court to dismiss count 1. Is that what you talked with Mr. Aaronstein about before this hearing today?
Yes, it is.
Did you have an opportunity to review this 3-page plea form with him before this hearing today?
Yes, I did.
Do you understand what it says?
Yes.
Do you have any questions about it?
No.
Did Mr. Aaronstein answer all of your questions about this plea form?
Yes, he did.
All right. Mr. Willis, do you believe you had enough time to sufficiently consult with your attorney about your entire case before this hearing today?
Yes.
And have you had an opportunity to review and or discuss the evidence that the state has against you with Mr. Aaronstein before today?
Yeah.
All right. Mr. Prosecutor, would you please put on the record whether or not the state provided all discovery evidence, including any Brady material evidence, any to your knowledge to the defense?
To the best of my knowledge, all this.
All right, Mr. Aaronstein, you acknowledge the same?
Yes, Your Honor.
Mr. Willis, are you satisfied with your lawyer, Mr. Aaronstein?
Yes.
All right. Now, do you understand this charge against you in count 2, having weapons while under disability, felony 3rd degree?
Yes.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in count 2 of the indictment?
Yes.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes.
Now, this being in count 2, this being a felony of the 3rd degree, do you understand you're facing a sentence, a potential sentence range from 9, 12, 18, 24, 30, up to 36 months in prison?
Yes.
And up to a maximum fine of $15,000.
Yes.
Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years?
Yes.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that?
Yes.
Are you on post-release control right now? All right. Do you understand that if you are on post-release control, and what I'm talking about now is if I sentence you to prison, you're released on post-release control, and you committed a felony offense, and you're convicted of that felony offense while on post-release control. In addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand that?
Yes. I do.
All right, do you have any questions so far? Well, Mr. Willis, in addition to the sentencing range that I, potential prison range that I explained to you, since this is a felony of the 3rd degree, community control is a possibility. Do you understand that I can place you on probation or community control for up to 5 years instead of sending you to prison?
Yes.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by the court?
Yes.
And by placing on community control, and you violate the conditions of community control, and you're going to be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time between that 9-month and 36-month range. Do you understand?
Yes.
All right. Also, if I impose court costs and you fail to pay those court costs, I can just order you to do community service instead of paying court costs. Do you understand that? All right. Do you have any questions so far? All right. Well, Mr. Willis, I do want to tell you that if I were to place you on community control or probation, I would fully expect that you would be successful. But can I tell you a few ways that people are not? All right. The first way is that some people commit a new offense or are convicted of a new offense, crime. That's an immediate and direct result of consequence or violation of community control. Do you understand?
Yes.
The second biggest way is that some people just don't comply with all of the conditions of probation. So if there are 4 conditions or 8 conditions, if you don't complete all of them, that's an immediate and direct violation of probation. Do you understand?
Yes.
And then the third biggest way, which is not so commonly known, and that is some people leave the state without permission of probation department or the court. Do you understand that?
Yes.
That's an immediate and direct result of violation of probation. Do you understand? Now, that's not to say you can't leave the state. It's just getting that permission when you're on probation. You understand that? All right. Any questions so far?
That's one question.
Yes.
The felony that is this is just a future reference. Is there a way, or is it possible that I could possibly get expunged down the road? Is there a possibility that I could do anything like that? Or is it just, otherwise, the judge could make sure that offense would not be expunged?
Okay. All right. Good question. When you plead guilty, you give up some very important constitutional rights, and I need to make sure that you understand. Do you understand that you have a constitutional right to trial, either to the court or to a jury of 12 persons? Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes.
Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond reasonable doubt? And finally, do you understand that at a trial, you cannot be forced to testify against yourself? Do you understand that?
Yes,
Do you understand your duties, rights, as I explained them?
yes, I do.
Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed here today? Do you understand that if you plead guilty to this offense in count 2, you are waiving all of these important constitutional rights in this case? Mr. Willis, knowing everything the court has discussed with you today, you still to enter a guilty plea as charged in count 2, having weapons while under disability of felony of the 3rd degree. All right. Counsel, is there anything further before I accept the plea?
No, no, the only thing I would add to him, just so because at some point, I might be able to find a motion for relief from this thing. And I want to say, like, I have something out of certificate of receipt that I'm going to do, that's what it purpose.
Yeah. All right. May I hear some facts?
November 20th, 2025, Hamilton County, Ohio, defendant possessing a firearm, had been precluded from doing so for prior conviction for aggravated robbery.
All right.
The traffic stop, comes in the car, he was like cooperative, did inform law enforcement of that time.
All in the car.
I'm not sure.
Was the
But he did say he was in the car, like cooperative.
Thank you very much. All right. Anything on the facts, counsel?
Yeah, what I would say is the stop was because of a traffic ticket in Georgia, which turned out not to be able to be cleared.
Oh, okay. All right, thank you very much. Anything else on the facts? All right. Mr. Willis, did you hear the prosecutor said you did?
Yes.
Is it true?
Yes.
What is your plea to count 2, having weapons while under disability, a felony of the 3rd degree? Let the record reflect that Mr. Eddie Willis was present in court with his attorney, Mr. Hal Aronstein, and that Mr. Willis was informed of all of his constitutional rights in the state of knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Willis understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Eddie Willis guilty as charged in count 2. Having weapons while under disability, a felony of the 3rd degree, in violation of revised code 2923.13 subsection A2. Count 1 of the indictment is dismissed at the state's request. Counsel, is there any reason why sentence should not be entered today?
We encourage you to step.
Yes.
I know you're encouraged to start at the side.
Yes. All right, Mr. Ernestine, what would you like to say on behalf of Mr. Willis?
Judge, as you heard, he's 36 years old. He's a graduate of South High School in Cincinnati. He did have a prior conviction in March 2011. He did serve 5 years on that and successfully completed his first release control. He's had nothing in consequence since that day. He's been married for the past 7 years to his 2 children. He works for RPD, as you can see, that's at the front of the show. He was quite cooperative with law enforcement. The weapon, in fact, belonged to his wife. Originally, he was on electronic monitoring. I had filed a motion to have him removed from electronic monitoring. He reviewed the report from electronic monitoring and felt that he had to show a bit more before we were willing to take him off of it. We continued it for maybe a month or 2. We came back, we were impressed with his ability to follow rules, and at that point, we did the electronic monitoring. So he's been off of it ever since. He stayed in constant contact with me. I understand the nature of the charge. I thought this question about getting that previous
Thank you. State,
Mr. Agent, prior to 2012 for aggravated robbery, kidnapping in public county at the time. Since being released, I see no other convictions from that. He wasn't informed, he wasn't placed robbery, did inform officers there was a firearm in the vehicle, was found in the center console, he wasn't peaceful occupant of the vehicle.
all right, thank you very much. Mr. Willis, is there anything you'd like to say before I pass sentence?
I just want to say that, you know, the address the library in this situation. You know, I want to say I teach, I coach, and I'm just trying to put myself in that, I need to put myself in that position, you know, that people are aware of the situation that I'm in. So, yeah, I'm just, you know, I'm moving forward with this in a more powerful way. I can see the positive way. So I just ask that Mr. Media see the situation because this situation is not right, it's not all it doesn't get it. I'll definitely move forward, I want to do that.
Mr. Willis, I noticed that you have, you have a client with you and you work with MRDD. How long have you done that?
This is what kind of basis and I pretty much was working for a whole lot.
Well, not 5 years that you were in jail.
Well, of course.
Yeah, so tell me, how old were you when you went to jail?
I was 20 years old.
So 20 to 25,
Yes,
you're 36 now.
yes.
All right. Do you get it now about the guns? You know, possess it, you know? Take special people, special artists to work with MRDD clients. So that tells me a little about you, for sure. All right, the court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender or other similarly minded, and to punish this offender using the minimum sanction that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I recently calculated this sentence to achieve the 2 overriding purposes of felony sentencing, and to be convinced with it not leading to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Mr. Willis, I hereby sentence you to a term of community control of 2 years into supervision. You will be submitted to drug and alcohol testing, you understand? And you will pay court costs, so no fine. And if you violate the conditions of community control, as I told you before, the worst case scenario, I will not hesitate to sentence you to a term of up to 36 months in the Ohio Department of Corrections, do you understand? But some of the consequences are that I could impose a longer term of community control or probation, do you understand that? And then there are other restrictions that I could place on you on a violation. It just depends on the severity, do you understand that? All right. Now, if you just do very well on probation, Mr. Willis, that is, you continue to keep a job, continue to work, and you continue to move forward on a positive path, and you don't have any new contacts with law enforcement, I will consider releasing you from probation early. All right. Anything else, counsel?
Judge, since he does have a issue with it, can you report to the patient tomorrow?
Okay, so.
Okay.
Can you do that?
Yes.
Okay, all right, so, you need to report probation, and, there will be another forfeiture. Sorry, I didn't say that, firearm forfeiture. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. You understand? I wish you luck.
Thank you, Judge, appreciate it.
Mr. Fox, what's your comment?
Your Honor, we plan to have a trial, so it's my understanding that there's a paper trial, a lockup.
Yeah, I just need to see if the state you prepared with all your witnesses.
Not currently, Your Honor, but I got notes in the hallway.
Can you check, yeah, can you check please?
Kathy Howell. You are.
All right, so Mr. Futrell's case, I probably need to get it, Mr. Mr. Ranger, just going forward, right?
Please so.
Okay. So I need to, Mr. Futrell is not.
If we can be off the record, I've told counsel that basically any plea negotiations need to happen before we start the trial. I don't know if they intend to talk to one last time.
Okay, sorry.
I didn't ask them when I came through.
I didn't see it, Your Honor.
Did you ask him?
Up to this point, we are substantially far apart in terms of expectations, so I'm not expecting it to be.
All right. Can I see Mr. Crosswell and Mr. Fox side or the Ms. Howard, can you coordinate, we have some pretty quick,
On this, we have to start at 7, because he's out of time on 7:31. Everyone.
Yeah.
Right.
Yeah. Okay.
You're at a point where
Just a moment, I gotta start this trial. All right. So the July 7th is the date we're looking at.
Yes,
All right. You have, what do you guys think? I have your down right now.
They're coming down.
I need to bring them down, but you're gonna do something, but we can take care of it. I don't have much time.
Ruben Mendez.
Look at prosecuting staff.
Yeah.
This is the matter of State of Ohio versus Mr. Emmett Petrell, case number B250575. Mr. Petrell is present in the courtroom with his attorney, Mr. Brandon Fox. Mr. Nick Oswald is present in the state of Ohio. This matter is set today for jury trial. Defense, are you ready?
You're right.
All right, and state, all right. So with this case being ready, I have another case that's ready, and it's really older case and the person's in custody. I have to take that one first. If that can resolve, then I can do Mr. Petrell's case, but I'd like to let it be set. Mr. Petrell, this time, how do you want to be set for jury trial?
For bench trial.
All right, I'll do a waiver.
Yes, sir.
Does that say anything about?
Your Honor, I would not be available for 7, I would really.
All right. If I would look also, it actually costs your costs. Yes. Thank you. I'm being handed a single-page document entitled Waiver of Trial by Jury. At the bottom, I recognize Mr. Fox's signature, with Mr. Petrell, is your signature right above? All right. This is an acknowledgement by you that you understand that you have a constitutional right to have a jury trial, which actually is set for today. But when you sign this form, you're indicating to the court, I understand my right to have a jury trial, but I don't want to have a jury trial. I'm waiving my right to have a jury trial, and I want to have a trial to the court. Is that your understanding of what you're doing when you sign this form? All right. Do you have any questions about this form? Do you have any questions about your constitutional right to have a jury trial? All right. And it is your desire, Mr. Petrell, to have me, the judge, decide the facts and the law of your case? All right. Well, because I have a jury trial getting ready to start doing this, Petrell, I'm going to go ahead and reschedule your case for a bench trial to accept your waiver of trial by jury. Mr. Fox, you would mind giving the case number here?
I would have it, yes.
Ms. Howard, can you get it? It is August 19th.
Wednesday, August 19th.
19th at 10 a.m. will be your next trial, Mr. Futrell. And I won't have any conflicts with that, okay? All right, also, because we're getting close to the speedy trial time, does your client waive speedy trial?
For purposes of going to bench trial,
All right, so the time will be waived August 8th, from today's date, June 29th, to August 19th. And you and your client line executed this waiver. Yeah, all set. Yes, thank you very much. All right, Mr. Futrell, I have in my hand a single-page document entitled Defendant's Waiver of Speedy Trial. I saw you sign something. Is this what you signed, sir? And is this your signature right above Mr. Fox's? All right, thank you. So this is a document by you that you understand that your case has, you have a right, a constitutional right to have your trial brought within so many days, but you are waiving that right and giving your attorney permission to continue your matter to August 19th at 10 a.m. Is that what you're doing? All right. And that's with your permission? All right. All right, well, we'll see you back on August 19th at 10 a.m. I'll be ready, your attorney will be ready, and you will be ready, okay? Thank you. This is the matter of City of Ohio versus Davion Stillwell, case number B2600-409A. Mr. Stillwell here? He is. Mr. Stillwell is present with his attorney, Mr. Neil Batchelor. This is across the City of Ohio. This matter is on today for a plea. And, do we have a plea?
So I've been trying to get this worked out. I'm asking for, I know that you have a jury trial. I don't know if we can come back tomorrow in order to do this plea, because otherwise I have to read the plea things.
So there is an agreement reached?
There is an agreement, Judge.
Okay. So what we can do is, we can do one of two things. You can either come back on a break today, which is 2:45, or we can reschedule the plea.
So I cannot come back today at 2:45. I know there is a co-defendant in this case, but I don't remember what day.
I think July 7th. I think July 7th for a plea, right? It's out. Yeah, I think it is up there earlier. You want to come back in?
What day? I'm sorry.
July 7th for a plea. Yes. At 9:30. Which is pleasure, July 7th or 9:30?
July 7th, 9:30.
Yeah.
Next Tuesday. Yes, sure.
All right.
Tuesday.
July 7th, that's next Tuesday. All right, next Tuesday, 9:30, we're complete. All right, young man, that's when it will happen.
Thank you.
All right, thank you. All right. We'll be in recess, to start the trial. Mrs. Howard, you can call back, Yes.
That's literally what you.
I'd be more than that, you're gonna do this. I'm not trying to.
She's waiting for this.
John, you know, shit. Can I just grab one of these for your illustration? Please grab one of those chairs for your facility or short chair.
Need the vote to tell for a second, so you would replace. So that's what we did. So we got to like.
Mr. Moore,
Yes, sir.
there's a rolling chair over there on the front. It's up to you. It's probably more comfortable than that chair.
Yeah.
It's up there behind that desk.
Perfect. Do you want to make it?
Yeah.
every time we have to talk to Mr. President. It's a good back in you guys.
Okay.
He's having one day.
Should we go with the jury?
Yeah, we have one motion to file, Your Honor, on Friday afternoon with the.
Friday at noon.
Yes, the court will copy that.
Did you bring a copy to my staff? If you did not bring a copy to my staff, which is required, I did not see it yet.
Your Honor,
And
we
we
filed,
worked over the weekend, so if you filed it, it may not have gotten to the system, so it's not the system. Is it the system? It's still not the system, so how do I know that?
I emailed a copy of Ms. Howard and Mr. Rendering on Friday afternoon. We filed it, I believe, there's a time stamp on there, 3:53.
Oh, 3:53?
Yes, Your Honor. It was in response to us getting the,
It's 3:53, court closes at 4 o'clock, but
Yes.
7 minutes before the court closes. If you did not hand deliver a copy of the salary at 3:53, we did not know about it. This is how this work always ends. Is that what you were programming?
Amen. I'll give you a six.
He came to you at 4:04? Oh, we were gone at 4 o'clock.
Yes, sir, I apologize, we stopped by the work block.
Yes, we gone at 4 o'clock. All right, Mr. Ranger, did you get a copy of the defendant's motion for relief from prejudicial surrender?
I did, Your Honor.
All right, you guys want to be heard on it?
Yes, sir.
Can I go to the jury?
Yes, sir.
All right. We'll go to the jury, you can line up. This is the matter of State of Ohio versus Isaiah Church, case number B 2500241. Mr. Church, the president of the courtroom, his attorney, Mr. James Moore, Mr. Rustin Winston, Mr. John Ritter for the state of Ohio. This matter is set today for jury trial. Other than the motion for relief from prejudice from joinder, which the court just received a copy of, are there any other motions that the defense is going to want to address that I haven't seen?
We don't have any additional motions.
All right. All right. What would you like to say on behalf of Mr. Church?
Your Honor, just briefly, we filed a motion for relief of prejudice from joinder. In essence, we had a plan, a trial strategy that we think was sort of unified between the two alleged victims in this case. The court's ruling prohibiting us from referencing the matters that we're talking about under seal. I'm not sure if I wanted to put this on the record as such, but ultimately the court's ruling.
I know what the ruling was.
Yes, that sort of changed how we have to approach the case in a way that sort of destroyed that sort of unified theory that made the two alleged victims connected in a way that is not prejudicial to the defendant. And now without that, we think there are basically two separate rape charges here. And if you try separately, there really won't be anything that will cross over between this law
in two separate trials, and so we're just saying that, we'd like, two separate trials. We're ready to start either one today, we just want any other questions.
All right, thank you. State?
Chair, I would like the court to strike the motion for being untimely filed. I received it at, I believe, 4:04 PM Friday afternoon, so it was outside of business hours, for a literally last second motion to change the scope of the trial. This should have been filed significantly long ago. The alleged prejudice has been known to all involved for months, if not over a year. I know it's been couched in terms of the court's ruling that was, I believe, disclosed. Disclosed, yes.
Can you turn your mic off, please? Sorry.
Oh, I'm sorry.
Disclosed.
Sorry, so I know it was disclosed on Friday afternoon. From my vantage point, nothing about the court's ruling on the proposed rape shield evidence changes or modifies the potential source of prejudice for having these cases, these charges heard all at once. Moreover, in terms of substantive response to the motion, these two circumstances with these two sisters are inseparably linked from each other. The one victim's report of what happened triggered the other's report. The one victim's, I'll describe this as her reaction to being allegedly raped, led to the circumstance that permitted the defendant to have access to the second alleged victim. It would be impossible for the state to present this case without talking to some degree the allegations of one victim and the other victim's case. I can't proceed on my case in a realistic way without at least some mention of the allegations included in the separate counts. These happened within months of each other in the same physical location by the same perpetrator in the same general manner. So in terms of substantive response, I can't see how this could be severed. In terms of procedural, this is the type of motion that we should have dealt with a long time ago so that the state could prepare its case differently or substantially differently, or have a more significant response. So this is, I can't object strongly on this, Your Honor. Thank you.
All right, Mr. or anything else?
Just, yes, I think we addressed the substantive issues, as the list of time, again, this was just motivated by, when we received word, on what we wanted to talk about during the trial, and not in this sort of, change over the course. It is.
First of all, for the record, the court notes that this motion is very untimely. To give the court a motion of this type, of filing at 4:04 PM on Friday before the trial, is not only disrespectful to the court, but also just against fairness and quite frankly, contrary to rules that foster transparency fairness, and timeliness. But even with that said, just looking at reviewing the motion, looks like there are, 4 counts in the indictment. 3 counts of rape, 1 count of unlawful sexual conduct of a minor. And it appears that counts 1 and 2 allege sexual assault occurring between April and May of 2024. And count 3 and 4 allege sexual assault conduct in March. So we have March, April, and May, a period of time that is a very short period of time for all 4 counts, alleging 2 victims, which are sisters. In reviewing and determining the issue of the prior pretrial motion, the court has become familiar that these are sisters who live together, who were had some contact with the defendant in a home environment, is my understanding, in a short period of time. I do not think that the defendant is prejudiced by the joinder of the counts in the indictment, and so I'm going to deny the motion and we'll go forward. Okay, Mr. Moore, Ms. Winston, is there any other motions you want to address before we will begin with jury selection?
Other than motion to set person.
All right. Well, that will be granted.
In response to that, Your Honor, I would ask that Detective Hollyfield be made her designated representative of the state.
All right, and first name of the detective?
Carrie, C-A-R-R-I-E.
Hollywood,
Hollyfield, H-O-L-L.
like H-O-L-L-Y.
Y. F-I-E-L-D.
Thank you. Detective Carrie Hollyfield will be designated as state's representative. He may sit at counsel's table. Additionally, even though this is separation of witnesses, it's my understanding that Marcy's law that any victim is permitted to be in the courtroom during the proceedings. All right.
And I have mentioned to both of the alleged victims that they have the right to be present during the trial. The way I'm expecting, unless they change their mind, is they may choose to be present for the entirety of voir dire, but they both expressed that as soon as their testimony is done, they would not like to be present, so I don't expect that to be an issue. I'll make sure to point out to counsel and to the court in case that does change, in case there is some problem about that.
All right, thank you very much. All right. I will note for the record, there is no jury panel member in the room at this time, that Mr. Church is present in court. He has on regular clothing. He has on a collared shirt. Looks like navy or black pants, white socks, and dress shoes. And he is not handcuffed, is he? Okay, and he is not handcuffed. That's for the record. All right.
Your Honor, may I put something else on the record?
Yes.
I think it's helpful just to make sure that the record's clear in terms of the negotiations up to this point. I understand, or my understanding of the law is, if the defendant is convicted, at least count 1, he is facing life without parole as a mandatory outcome. Up to this point, I would say that he has not made any kind of plea offer that is remotely close. And I want to just make sure that he understands what potential ramifications he's facing if convicted on this, so that there's no mistake in terms of the potential appeal down the road about him not knowing what he's getting into.
All right, counsel,
Your Honor, as far as the negotiations go, there has
is your microphone on this?
Your Honor, as far as plea negotiations go, Mr. Rendering is correct that there has not been substantive plea negotiations to any great extent. However, we would note our interpretation of the statute is that the defendant faces 25 years to life for life without parole on count.
Mr. Renner, did you say up to life or did you say life?
I believe it's life without parole, Your Honor, based off the alleged age of the victim, being that she was under 13 and that there's an element of force. And so I believe that her being under 13 places this into a life sentence, and that the additional force is established, then that puts into life without parole.
You know, our understanding of the statute was that because it is under 11, there's force. Under 11 would be, I believe, 10 to life. Force takes it to 25 to life, and I think this is prior is when it becomes life without parole.
Is there a prior?
There's not, there are.
All right. I want to get some agreement first on what the sentencing consequences are. And because I want Mr. Church to be fully informed and advised.
Chamber Garcia should be the force part of the means.
So my understanding of the force part is that
Basically,
Yes.
it says that you can do, you get a set sentence of 20 months to life. Because it's, so that,
All right, council, you all come, and we will go to our jury room. Off the record. Ms. Allen.
all. Okay.
All right, for purposes of the live stream, I do want to let the public know that this trial is going to be a trial involving very sensitive, of a sensitive nature with serious allegations against minor children. And for that purpose, I am going to terminate the live stream at this time. For privacy and protection rights of the alleged victims who are minor children. So I will terminate the live stream at this time.
Your Honor, may I have about 3 minutes to speak to the victims or those victims?
Is it true?
Mm-hmm.
All right.
I'm gonna walk away since the